That's not.
You can go on,
he
counsel, because I can solve the whole transportation issue. I can put him right next door downstairs next to me. Court does call the case of the People versus Marcus Jackson.
I know O'Brien on behalf of defendant present.
Before the court gives its decision, I think I should place this on the record that the, I guess at this point, the alleged victim in this case did directly email the court regarding some of her concerns. And so the court wanted, first of all, and I, upon receiving it, because it was, in my mind, improper to send that directly to the judge, I had my staff forward copies of that email to both the prosecutor and defense counsel in this case so that they knew and were apprised of everything that the court had seen or looked at. And so that was part of our defense conference in this case. All right. Anything else from either side?
Your Honor, at this time, my client would be changing his plea pursuant to the 769-4A statute to guilty.
Any response from the people?
Yes, my understanding is that defense counsel is saying that this particular incident didn't happen and wants to try to change the offense date. And I think it's still going to be in Superior Township, and would like to here for the factual basis of the unwanted touching. I don't believe it's appropriate. As court has heard testimony, I would ask the court to enter its finding and not sentence under 4A.
Well, so that I'm clear, you're attempting to enter a plea to something else that happened or a plea to this offense?
It'd be this offense, but it's actually a different date, Your Honor. Rather than October 3rd, it would be September 27th.
Maybe I said that wrong. I realized that the offense would be domestic violence.
Correct.
But you're saying not to the domestic violence that this court has heard testimony on?
Your Honor, the testimony was regarding October 3rd. What Mr. Jackson would be entering a plea to would be as to a date of September 26th.
I'm not gonna do that. I'm not gonna do that in this case. I mean, I think there was a conversation regarding the an entry of a guilty plea prior to the court making its finding, but I'm not gonna take it to something wholly and totally separate from this event.
The only difference, Your Honor, is the date.
Well, that wouldn't be the only difference, would it? I mean, the events themselves or the facts would be different.
No, Your Honor, the facts would be the same.
Okay, so that I'm clear. He wants to enter a plea where the facts may, and I'm saying may, indicate that he had grabbed the victim in this case by the collar, and in doing so, she fell to the floor and injured herself.
Correct.
Anything additional from the people?
I think that doesn't sound like a plea to me. But
Pardon?
I would object to that. I would just ask the court to find its finding from the testimony. You can't just take a plea from a different offense date with a different set of variables.
The variables are the same. The only change is the date.
You just said Your Honor, the court just asked defense counsel that he grabbed her collar and she fell and hurt herself. That's not what she testified to as happening. That is not the same set of variables.
That's not what, who testified? I'm sorry.
That's not what the victim testified to. She didn't say she hurt herself. She said she was shoved down and the injuries were a result of that shove.
I mean, is that, I think.
However they want to word it, Your Honor, we honestly don't care if that's what the specific verbiage. I don't see the difference.
Well, I do. There's a huge difference in that. Because, and, you know, I think I'm just going to make my finding because my difficulty is that I have this feeling that I would be taking a plea to something that may or may not have happened. And I don't want to be involved in that at all. So the court in its findings, first of all, let me just say this, that I found the testimony of Miss Gorborkin. I found her testimony to be very credible in terms of what had occurred on the date of October 3rd, 2022. I also found that there was no dispute that there is the requisite relationship is between the parties. Specifically, the court would find that the defendant was indeed grabbed by the collar. She was pushed down, fell to the floor, as she described it, a hardwood floor, and that injuries did occur to her legs and to her ankle. The court would also find that the defendant, that this wasn't some accident as he described it, or some circumstance where she tripped and fell. And the court would also note that I find that the testimony of the defendant in this case to be highly suspect, and well, not highly suspect. He has no credibility in this court's mind. By his statements, the statements he made, his testimony here on the stand, this just didn't happen. I don't believe that to be the case at all, that it did happen. And his subsequent statements to the police all have this court not believing anything he said. So for that, encompassing everything that was testified to, particularly by the victim in this case, the court would find that the people have indeed sustained their burden and would find that the defendant is guilty of this offense. The defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
October 30th at 1 p.m.
October 30th, 2023 at 1 p.m. I will at this time make that via Zoom. Any issues regarding the defendant's bond in this case?
I mean, the people have concern given the guilty verdict that they are currently staying in the same household and have contact, but after speaking with the victim, she does not want him to be incarcerated. It's my understanding she wants to be able to speak with him, and they have together, and she wants to be able to speak with him. I mean, the people would object to that and would ask for the change, but it's my understanding that is not what the victim wants.
Anything from defense?
That is correct, Your Honor. They are residing together. They do have 2 children, as we did advise the court. We did resolve most of the divorce matters on Friday. They have minimal, they just have to decide the division of personal property. At this time, Your Honor, Mr. Jackson is the sole financial provider for this family. And if he goes to jail, he will lose his job. If he is not able to obviously show up for work, he'll lose his job. And there will be no funds to provide for this family. As the court is aware, this matter's been pending for almost a year. There's been no bond violations. They've obviously figured out how they can cohabitate without issue. It's been consensual contact since the court lifted the no contact. And I would just ask the court to leave that the contact as consensual only.
Part of the court's concern is in all domestic violence cases, there are certain points that are sort of highlighted danger points, and this is one of them. If I were to change this to no contact pending sentencing, where would the defendant reside?
My client has indicated that if the court puts the no contact order back in place, then he would reside at his mother's.
Located in what city?
Lansing. But he works here in the area here, so it would create a huge transfer. He'd have to commute back and forth to work. But that's not.
You can go on,
he
counsel,
can
because I can solve the whole transportation issue.
Right.
I can put him right next door downstairs next to me.
I know. So he can stay at his mother's house. He's got a place he can stay. That's not an issue.
All right. I'm going to change the sentencing date in this matter to October 16, 2023 at 1 p.m. That will be via Zoom. I am, however, with a little bit of reluctance, going to reinstate the no contact provision. The defendant is to provide the address to probation and to the court that he will be residing. But at this juncture, you're not to have any contact. You understand that, sir?
Yes, sir. Yes, Your Honor.
And that is, and when I say no contact, I mean direct or indirect contact. I don't want contact between third parties contacting her. You understand
I
that?
understand, Your Honor.
And you also understand that also encompassed in that no contact provision is I don't want any comments on social media or anything else along those lines. So that includes any electronic transmission of that would constitute contact. Do you understand that?
Understood. That won't be an issue, Your Honor.
Okay. Is there anything further from either side?
Your Honor.
No, Your Honor, thank you.
Thank you.